What about factors of mitigation in criminal cases? California has a determinate sentencing law that spells out a punishment range for most crimes. The possible sentences in a California felony case are known as the lower term, middle term, and the upper term. The judge selects your sentence based on aggravating and mitigating factors. In addition to influencing the judge in the selection of your sentence, some aggravating factors can be charged as sentencing enhancements that carry additional repercussions. However, just like the underlying charges that you faced, any sentencing enhancement must be proven beyond a reasonable doubt, or you can't receive additional punishment. You also can't be punished for a sentencing enhancement if you're not convicted of the underlying offense. Prior convictions can't be used as both sentence enhancements and aggravating factors. Just like the aggravating factors that influence the outcome of a California criminal case, mitigating factors are also divided into those related to the offense and those related to the defendant. The following are mitigating factors related to the offense that can be considered in a California criminal case. First, the defendant was a passive participant or played a minor role in the crime. Next, the victim was an initiator of, a willing participant in, or aggressor or provoker of the incident. The crime was committed because of an unusual circumstance, such as great provocation, that is unlikely to recur. The defendant participated in the crime under circumstances of coercion or duress, or the criminal conduct was partially excusable for some other reason not amounting to a complete defense. The defendant, with no apparent predisposition to do so, was induced by others to participate in the crime. The defendant exercised caution to avoid harm to persons or damage to property, or the amounts of money or property taken were deliberately small, or no harm was done or threatened against the victim. Or the defendant believed that he or she had a claim or right to the property taken, or for other reasons mistakenly believed that the conduct was legal. The defendant was motivated by a desire to provide necessities for his or her family or themselves. The defendant suffered from repeated or continuous physical, sexual, or psychological abuse inflicted by the victim of the crime. And the victim of the crime who inflicted the abuse was the defendant's spouse, intimate cohabitant, or parent of the defendant's child. And the abuse does not amount to a defense. Now, these are the mitigating factors related to the defendant. First, the defendant has no prior record or has an insignificant record of criminal conduct, considering the date and frequency of the prior crimes. Or that the defendant was suffering from a mental or physical condition that significantly reduced culpability for the crime. The defendant voluntarily acknowledged wrongdoing before arrest or at an early stage of the criminal process. Or the defendant is ineligible for probation, and but for that ineligibility would have been granted